Hello, I'm Michael Ruger. I'm the managing partner at Greenbush Financial Group, and today we're going to be talking about the tax rules surrounding when you inherit a piece of property. So this is a very common occurrence. A lot of times your parents owned a house for a long period of time, they pass away, and then the house is inherited by the kids. We get the phone call then saying, when we sell the house, how much tax are we going to owe on this piece of property? And the answer is going to vary based on how the house was titled, how long it was held for, and other variables. So we're going to go through those now. So most assets that you inherit that are not in a retirement account receive what's called a step-up in basis. And what a step-up in basis is essentially the cost basis in the property, whatever your parents paid for it, steps up upon their date of death. So the way cost basis normally works in a property situation, so let's say I buy a piece of rental property for $100,000. So that's my cost basis. I then hold that piece of property for 20 years, sell it for 200 grand. When I sell it for 200,000, 100,000 comes back to me tax free because that's my basis, and then the other 100,000, which is the gain, I pay tax on. Now, in an inheritance situation, let's say I inherit my parents' house. They paid, let's say, $100,000 for that house 30 years ago, but on the day they passed away, that house is worth $300,000. What happens is, on the date that they pass, I receive a step up in basis to whatever the fair market value is of that house on the date they passed away, which is $300,000. If I sell the house the next day for $300,000, I pay no tax on that transaction and I receive the $300,000 tax-free. So you can see why it's such a big benefit to make sure that step up in basis happens. Now, that step up in basis does not protect the appreciation that happens after the date of death. So we've had scenarios where parents pass away and for some reason they don't sell the piece of real estate for a year after. Sometimes it's because they're going through the probate process. Other times people are holding on to it because they rent it out or they just want to hold it for whatever reason. If there's appreciation between the date of death and when you sell it at a later date, that is not protected. So again, parents pass away, house is worth 300 grand, I hold it for a year, and then I sell it for 350,000. I get 300,000 tax-free because that was my step up. The 50,000 in gain that I made, that I will still have to pay capital gains tax on because that's the gain piece. Now, the mistake that we see people make, and this is frequent, is when they're still alive, they decide, I'm going to gift the house to my kids to get it out of my name. And they do that to protect the house from a long-term care event down the road if something were to happen. The problem with this is when you gift an asset, whoever you gift it to inherits your basis in the property. And when you pass away, that does not get a step up. It doesn't get a step up because you don't own it and it's not part of your estate. So in that example, my parents gift the house to me while they're still alive. They paid $100,000 for the house. My basis in the house is now $100,000. They pass away. When I go to sell the house for $300,000, my basis is still $100,000. I have $200,000 worth of gain that I have to pay tax on. And based on long-term capital gains rates and state income tax rates, that could be a $40,000 plus tax bill that maybe I didn't have to pay if it was structured correctly. And the way you can do it differently to avoid this scenario from happening is people will set up what's called an irrevocable trust. So by having the house owned by an irrevocable trust, if you get past the 5-year look-back period from Medicaid, not only will that house be protected from a long-term care event, but as long as you're working with a knowledgeable estate attorney, they will put enough language in that trust document that says this is protected from a long-term care event, but on your passing, this trust asset will be included in your estate, so it gets a step up in basis. So you can have both benefits. But I can't express enough that you should, if you establish the trust, you should really work with a trust and estate attorney, not a generalist. Because if they miss language and you miss that step up, it could cost your beneficiaries a lot in taxes. And people sometimes shy away from the irrevocable trust because it may cost $3,000 to $6,000 to establish one of these. But when we look at paying $3,000 to $6,000 now versus potentially a $40,000 tax bill or having to spend down that asset as part of a long-term care event, a lot of times that money is well spent to go that route. If you have any questions about this inheritance or the real estate in general, feel free to give us a call at moneysmartboard.com. Thank you.